6 p.m. just to ensure that you get the full information to lead you to make up your own conclusions and draw your own conclusions about this Cooper's Pen land issue. So, Counsel, are you ready?
Yes.
All right. So,
Well, it
first,
feels weird. It feels weird not telling my YouTubers, listeners,
oh,
viewers.
go ahead.
Good afternoon. So, good afternoon, everyone. Thank you so much for joining us. Yes,
All
not Cliff.
You
George.
almost said Chris. Yeah. Good. All right.
Yeah.
So the first headline question, Counsel, is this: what actually happened at Cooper's Pen this week?
So, in short, what happened is a bailiff, along with police officers, went to Cooper's Pen. And the presence of a bailiff is very important here, George, listeners, viewers. A bailiff does not get involved at all unless it concerns a matter being dealt with legally. Because a bailiff, by law, is an officer of the court. So it's not to be seen as a private demolition, quote unquote. Yeah, because a bailiff only comes on the scene to execute a court order. So whatever you think about the manner in which it was done is one thing, but it was the enforcement of a judgment of the Supreme Court, and that is why you have the bailiff there. Now, that is the important part. And in fact, they're going back there to get rid of the other structures that are there.
Yes. All right. So that covers in headline form what happened at Cooper's Pen this week and the presence of that bailiff. Now,
Yes.
I want you to go in the detail that you have it prepared, because you prepared these remarks before you came here. The headline question: whose land is it, and how far back does this dispute go?
So it's a registered land. The volume and folio number, the subject part of it, 1008 volume folio 636. And the registered proprietor is New Falmouth Resorts Limited, which is a company registered under the laws of Jamaica. And the chairman and chief executive.
Top of the evening, people. Top of the evening, people. Yes, Faada Pow here. Yeah. So, we're gonna dissect a little thing, right? And I tell you, you know, these people not realizing that we're in the year 2026, where information can be gathered by a matter of keystrokes. And then for those who are willing to read and comprehend, we can have discussions on this information. So, I don't know how many of you have been following this Cooper's Pen thing in Trelawney, and how this gentleman, Isat Buchanan, comes out telling people that they can just, chop the line, claim land, And in it, he made some claims, some very interesting claims.
Wednesday,
Listen to
Wednesday.
this, people. Listen to this. This is George Davis
We
here
got-
talking.
we saw another
Listen to this.
pimple appear on the face of Jamaican politics. Or perhaps I should say, what appears to be a pimple. Could be worse. You may think it will mature into a black head or a white head. It could be mistaken. It could be chicken pox. First sign. If it's a white head or a black head, easy. Let it mature. Squeeze it. Move on. It's gone. If it's chicken pox, and if it's the first sign of the chicken pox, it's gonna leave a scar. And so we wonder if the face of Jamaica's politics will prove to have been scarred
Let me make a
by what happened,
change it. Give me a second.
what came to the public's attention rather, on Wednesday. And so Nora, play for me that video with the East Portland MP, Mr. Isaac Buchanan. So, as I noted, could be a little bump on the in the face, could be a white head, could be a black head, could be chicken pox. And like so many Jamaicans, I had chicken pox, and unfortunately I had it when I was a big man. It struck me down before the 2018 FIFA World Cup, the week before. And I had to double up my treatment and everything because I was not going to miss that for the world. We were broadcasting and everything. Are you ready now, Kevin? All right. They're trying to get that in order. So let me tell you then why they get that in order. Kevin, you just killed the sound clash a while ago, youth. Cheese and peas. All right, Nora says she has it now. Gosh, thank you. Let's go.
Open support was given for what is criminal conduct.
No, not that. Isaac.
Yeah. Choppy line pan them.
And even a recommendation was made as to what
We never up there. Take all 1 foot on the bed, broke it off and carry it up there and say, see where left here? Because anybody were in a that the place there where them bulldoze, you have to get back a house out of government.
Not it. That's not it. Kevin, I'm going to send the right one to you. That's not it. That what you're playing is a mashup of thing that contains reporting from elsewhere. I don't want that because we did our own reporting. So I asked for our reporting to be put in because I'm promoting our reporting. I just sent to you the video that I wanted to play. Thank you. All right, so they're lining it up. So it's the unedited version of, well, the snippet, undisturbed, of Mr. Buchanan talking on, well, it came to the public's attention on Wednesday. And I'm just trying to play for you the entirety of the snippet before we move further. So, waiting for it to come up. All right, we're ready now. Let's go.
To the people of Trelawny who wake up and then bulldoze your house, I feel your pain. Because you see the Prime Minister, him have to lift up off of some house. And him have to give you. And when him put him plaque on the house, then when half give you back. Rip it off when you're done, because if them not give you back house, Tova can't win down there. Right now, anywhere should there be a twep. Prime Minister have to go keep cabinet meeting and know so she have to give you back in the house. And we now ease up off of them neck. Because government are creatures of the constitution. And the human rights run this, the humans run this. Wanna bet me if you think I lie, me I tell. So someone will never up there. Take all 1 foot on the bed, broke it off and carry it up there and say, see where left ya? Yeah. Shoppy line upon them, cause anybody where in a that the place where them bulldoze you have to get back a house out of government. And it now gonna be no trail. I bet say you get land. I bet you know that. Yeah. So make could be dialectic thinkers now. And then you can screen record this and make Andrew know say have to find house and land for you now. And we'll never see back Trelawney. And watch. I go buy one green suit and put it down. But it's the truth, I know them like make video of me and say I hope I'm work. But I go buy one green suit and everybody when them I get them house, I go show up in my one green suit and say I told you so. Yeah man, miss it so. So when you think on the body, you know, when you don't have a clue, animal farm this. When you performative government, land is for the people. Wake the town and tell the people of Sri Lanka, St. Thomas to, you see this bulldozing thing are the last days of it. And if you talk to people like them are human beings, and you must treat people with respect, whether they have teeth, whether they have money. The Constitution is for the least among us. It is for us, by us. Yeah? We not get distracted about leaked emails. After we having a Pegasus and a leaked email count and want to go a CCJ count now wicked. You think we don't know what going about, we will not be distracted. So no go on. So before the start of the campaign, I got to lift up out of this. But I bet you no matter what happens this day, all those people have to get house from the government. This is embarrassing.
So my people, when I hear the argument there, what this brother put on, oh the government I got have to go do this and the government I got have to go do that, right? This brother I say, government I got have to give back land and government I got have to do that and I have to do this. Very interesting, man. Right? On here,
To the people of Trelawney who wake up and then bulldoze your house, I feel your pain. Because you see the Prime Minister, have to lift up off of some house. And him have to give you. And when him put him plaque on the house, then when him have to give you back. Rip it off when you're done, because if them not give you back house, Tova can't win down there. Right now, anywhere should there be a twep. Prime Minister have to go keep cabinet meeting and know so she have to give you back in the house. And we now ease up off of them neck. Because government are creatures of the constitution. And the human rights run this, the humans run this. Wanna bet me if you think I lie, me I tell. So someone will never up there. Take all 1 foot on the bed, broke it off and carry it up there and say, see where left ya? Yeah. Shoppy line upon them, cause anybody where in a that the place where them bulldoze you have to get back a house out of government. And it now gonna be no trail. I bet say you get land. I bet you know that. Yeah. So make could be dialectic thinkers now. And then you can screen record this and make Andrew know say have to find house and land for you now. And we'll never see back Trelawney. And watch. I go buy.
So my people don't hear that again, right? This brother said government I got to give them people a house and ray. So make we look on the next side right now, where some people decide say, okay, I'm gonna dig deep into this thing, and them go show
Executive
exactly
Officer is Mr. J.
how this thing works.
6 p.m.
Right?
just to ensure that you
Watch
get
this now.
the full information to lead you to make up your own conclusions and draw your own conclusions about this Cooper's Pen land issue. So, Counsel, are you ready?
Yes.
All right. So,
Well, it
First-
feels weird. It feels weird not telling my YouTubers, listeners,
Oh,
viewers.
go ahead.
Good afternoon. So, good afternoon, everyone. Thank you so much for joining us. Yes, now Cliff.
you
George.
almost said, yeah, good. All right.
Yeah.
So, the first headline question, Counsel, is this: what actually happened at Cooper's Pen this week?
So, in short, what happened is a bailiff, along with police officers, went to Cooper's Pen. And the presence of a bailiff is very important here, George, listeners, viewers. A bailiff does not get involved at all unless it concerns a matter being dealt with legally. Because a bailiff, by law, is an officer of the court. So it's not to be seen as a private demolition, quote unquote. Yeah, because a bailiff only comes on the scene to execute a court order.
Some of people, you hear that. A bailiff only shows up to exercise a court order. This was not some private person who them sending for bulldoze the people them house as they led us to believe. The bailiff is operating based on a court order. You see what I'm talking about? The misinformation that these people carry out time and time and time again. The misinformation. All right. But go listen to him again. Listen to him continue.
So, whatever you think about the manner in which it was done is one thing, but it was the enforcement of a judgment of the Supreme Court, and that is why you have the bailiff there. Now, that is the important part. And in fact, they're going back there to get rid of the other structures that are there.
Yes. All right. So that covers in headline form what happened at Cooper's Pen this week and the presence of that bailiff. Now,
Yes.
I want you to go in the detail that you have it prepared, because you prepared these remarks before you came here. The headline question: whose land is it, and how far back does this dispute go?
So it's a registered land. The volume and folio number, the subject part of it, 1008 volume folio 636. And the registered proprietor is New Falmouth Resorts Limited, which is a company registered under the laws of Jamaica. And the chairman and chief executive officer is Mr. James Chisholm. The information that I have here, that I have gleaned, is from my meticulous reading of both cases. And that's the case in the Supreme Court, the Court of Appeal. And I've also gone as far as to obtain the formal order from the previous court sitting, the claim in 2007, which predates the 2010 claim that involves all 99 persons, the 99 people on the land as at the time. Yeah? So the dispute has never been about who owns the land. That was not in dispute in 2007, not in dispute in 2010, not in dispute before Justice Campbell in 2014, and certainly not
That's
in the
Justice
Court of
Lennox
Appeal.
Campbell.
Right.
Good.
The dispute began in 2007, so it has now been running for 19 years. And it concerns about 9 acres of the land that has been occupied by a group of persons, said to be about 100 families, some of who have claimed to be there for more than 15 years, and some who says their families have been there for generations. They have built permanent concrete structures, they had water and electricity connected, and the judgment, again, describes it as a vibrant community. That description matters. And further down, George, you'll see why I paint that picture.
Stick up in. Listeners, viewers, audience, remember, the judgments that Said has examined describe it as a vibrant community. That is going to loom large in the further answers that Said will provide later on. Just remember, the judgment, it's not his opinion, the judgments of the court describe Orange Grove as a vibrant community.
My opinion comes out on the analysis of the judgments
That's
that
right.
I've read.
That's right. All right.
Yeah?
Let's squeeze this one in before the break, and take your time because we're going to have the time. What did the Supreme Court decide in the year of our Lord 2010?
So, in 2010, 2007, first of all, let's go back to that. New Falmouth Resorts Limited, they brought a claim against 99 persons for recovery of possession. That is an ordinary claim a registered owner brings against a person occupying their property without permission. That actually turned out to be a long trial before Justice Donald McIntosh. For it to be a long trial, George, and this is based on our experience in the legal system, it means that the defense that they had to the recovery of possession claim from the company was that they adversely possessed the property by means of being there for more than 12 years, undisturbed and in open possession. In 2010, April 6 to be specific, judgment came in favor of the company, and the judge made 3 orders. 1, recovery of possession of the land. 2, he ordered each defendant to pay damages of $50,000 for trespass and wrongful occupation. And 3, he ordered the defendants to demolish and remove their illegal structures from the land. And he granted an injunction restraining any further construction by any other defendant. And that third order is the one that's important, George, because the court did not simply say that they must leave. The court said they must pull down what they had built 16 years ago. It is unchallenged. It is on the record. They did not pay the damages. They did not demolish. They did not remove the structures. That judgment, that 2010 judgment, was never appealed, and it stands even today as the final judgment from the Supreme Court.
Very important. You hear what Saeed said? Those 3 orders, go again, not challenged. They didn't pay what the court ordered them to pay. They did not demolish, and they did not remove any structure. And that 2010 judgment, which ordered them to do those things, went unappealed.
Yes.
All right, very important. All right, stick with us. We have more ground to cover. I'm not going to take the time to do it because this thing is so important, because there are so many gaps, so many questions to answer, and we're trying our best to answer them for you, leaning heavily on Said Bernard's legal expertise and experience. Facilitate his explanation of the key issues surrounding this Cooper's Pen land dispute in Trelawney, that specifically that piece of property called Orange Grove, which has been the subject of much controversy after police accompanied the developers to demolish several homes earlier this week on Tuesday morning, putting scores of families out of their homes, unsettling lives, upending livelihoods, and we're here to answer some key questions. What Said Bernard has told us so far, based on his analysis of the court judgments and the related material, is that in 2007, the company that owned the land, New Falmouth Resorts, it brought a claim against 99 people who had squatted on the land for recovery of said land. On April 6, 2010, 3 years later, Justice McIntosh delivered a judgment in favor of the company and ordered the company to recover possession of the land,
Yes.
ordered each of the 99 defendants to pay damages of $50,000 for trespass and wrongful occupation. He also ordered the defendants to demolish and remove their illegal structures from the land and granted an injunction restraining any further construction. Saeed told us before the break that none of the orders from the court were respected by the defendants, and the judgment was never appealed. So now, Saeed,
And before you go
Yes.
to the next question, I want to make a point, because when you look on the formal order of that 2007 judgment for recovery of possession, of the 99 defendants, one of the defendants, in fact the 85th defendant, was persons unknown. You hear many people saying, oh, but I never know about the judgment, or I don't know if I was around at that time, or whatever. The persons unknown here, as is listed as a defendant, mean if you're there on the land.
Yeah.
Quite simple.
Right. Good. All right. So, what happened after 2010, Saeed? Did the matter simply go quiet? Did it disappear? What happened?
No. In fact, it went opposite. The evidence accepted by the courts in the 2010 case, where the minister got involved in, there was literally an expansion of the community. So the judge made an order, the community expanded. And the turning point came when the company, in trying to enforce the judgment that they got, they approached JPS to have the electricity supply to the unlawful occupants discontinued. That is what triggered a wave of applications now in.
So, my people, from all that we have heard so far, it sounds to me like this twip twip where you hear ISAT a run off, this twep twep, it sound to me like a PNP. I got twep twep, you know. Eh? Eh? It sound like a PNP. I got twep twep. Because seriously, this was a court matter. And the court had ruled. A very interesting thing here. Very interesting. Huh? So even though they are trying to tell us that, oh no, that is the government wicked. Look like we're gonna see who the wicked people are now. Who are the people who were trying to take away people? You see, it's a dangerous thing, you know, when government can just come and just take what people land, you know, and give it to other people. The law clearly states that you can take land, but there's a basis. There's a basis, right? This exercising of eminent domain is for government to build road infrastructure, not to take land and give it to other people. Huh? But we could go and listen to the thing and see how this whole thing now a work out. Because story I come to bump. Story I come to bump, man. And we get to see who it is that is really playing games. We're gonna see who is playing the games. Who it is that is trying to tell us one thing, but doing something else. Yes. Story I come to bump, you know. Yeah. I'm gonna see who is doing what. Make we listen some more. Tell you, man, all these evil deeds shall come to light.
Early 2012 to stop the eviction. So that segues right to the heart of the story, yes. I think, George. And that explains why the court eventually spoke how it did.
Yes.
Because in March 2012, 2 applications were filed. One in the 2007 claim for a stay of execution of that judge's judgment for demolition and recovery of possession, and another for an injunction to stop the company from interfering with the occupants. On the face of these applications, George, what was brought against the 99 defendants, but in substance, it was driven by the housing minister.
Who at the time was Dr. Maurice Guy.
Dr. Maurice Guy, I'm learning. The supporting affidavits were sworn by Mr. Joseph Shakir, who is the managing director of Jamaica, the housing agency of Jamaica at the time. And he described himself in the affidavit as the duly authorized agent of the Ministry of Housing. The basis of the application was that in February 2012, the minister had declared the lands an improvement area under Section 6 of the Housing Act, which the minister said left him at liberty to compulsorily acquire the land under the Land Acquisition Act. In May 2012, so this is months later, the minister then went ahead and lodged a caveat.
This is that controversial caveat.
And I'm going to get to that, George. The minister went and lodged a caveat against the company's title, which had the practical effect of freezing, not of dispelling, but of freezing the owner's ability to deal with the land as he or she saw fit. Yeah, they went on in May of that said year, the same days later actually, to then gazette the declaration of that being an improvement area. Now, when somebody places a caveat on a title, A caveat is there to say, I am stopping you from doing anything until a court has ruled. So you don't just lodge a caveat and you leave it like that and think that nothing will happen. The caveat can be warned, it can be cautioned, and things go on. But ultimately, George and listeners, once the court makes a ruling on the determination of the land as it relates to its legal and equitable interest,
Yes.
then the caveat, to my mind,
Yes.
is of no moment.
Hear me now. Good. You spoke just now about the minister moving to clear the area an improvement area. Therefore, what is an improvement area and what was the minister trying to achieve by virtue of this designation?
So the Housing Act actually gives the minister very important powers. Section 4, for example, it allows the minister to declare a housing area where further housing accommodation is needed. Section 5 deals with slum conditions and slum clearance, where conditions are so bad that you just need to demolish the entire area. Section 6 of the Housing Act, it deals with the improvement schemes, where houses are in an unfit area by way of shoddy house management, or the roads are too small, it is unfit for human habitation through disrepair or sanitary defects, and frankly speaking, dangerous to the health of those who occupy it. Yes? Section 25 then provides that land proposed to be acquired for such an approved scheme may be acquired under the Land Acquisition Act, and that the purpose is deemed to be a public purpose. And I'm going to come back to that. Very important. The purpose must be for a public purpose. So based on what happened in the case, the strategy seems to be this, George. You declare the land an improvement area. You use that declaration to compulsorily acquire it from the owner.
Yes.
You pay the owner compensation, and you'll be familiar with this. NROC does it when you want to, build roads. You buy the land from the person.
Yes.
But that's a public purpose. You want roads.
Yes.
Then you regularize the occupants on the land that were already on the land.
Yes.
In one sense, to my mind, it's a humane objective. People need to live. Some says land is for the people. But the difficulty with the act is that it was not designed to do that. And the evidence put before the court did not come close to meeting the statutory obligations.
So stick up in then. All right. What then did Justice McIntosh say when this matter returned to him, came back before him in 2012?
So, people that wanna beat them chest to them a big lawyer, cause them did depend certain case. So, you did spend any time and review the information before you run out and make TikTok video? A chat off your mouth? As my lady from the Goodly Dame said, chattings. You come with one bag of chattings. Did you do any research like what the gentleman from NNN has done? Did you do any research before you run out on this thing? And y'all make bet how Prime Minister have got to do this and Prime Minister have got to do that, and two over can win. And all them things you come with. But did you do any research? Because to me, that is what any good lawyer does. Especially if you call yourself big lawyer. But no, it doesn't seem like you do none of that. It sounds to me like you just jump on the wagon. Watch out now, them are gonna mash you up, I hope you did have put on something. As a matter of fact, I just think about it earlier this week when me hear you run off your mouth. I said to myself, say, then them people that when tell say they must chop the line. Them not can go chop him, man. Move in a film place and take it. Since I saw it go. Or you gotta defend it. You gotta defend it if them try that. Okay. I could go and listen some more.
He said this, and I'm going to quote it here. It's at paragraph 10. It was so important that it was quoted back by the judges of the Court of Appeal. Given the history of this case, because he had refused the application by this time for the injunction, and he spoke very strongly. In fact, he asked the minister to come to court. He did not come. He noted the presence of the legal officers of the housing agency, and he handed them a written copy of his judgment. His written reasons are part of it, paragraph 10, as quoted in the Court of Appeal. It says, given the history of the case, the length of the trial, and the efforts made by the court to assist the defendants, who seem to have been misled by politicians into squatting on private property, notwithstanding their unlawful act, this court emphasizes with the gullible defendants.
Let us stick a pin here. You hear what the judge say? Politicians, misleading people. Misleading people, telling them it can't. You see, pulling back the same thing that them was practicing in the 70s. If a man have 2 car, you go take one. A man have 2 house, you just move in a one. This capture mentality. This is what them coming back with. But them fail to realize a new set of people. But there are some who still want to hold on to this 70s mentality. It now go work in a 2026. Finally, the people them get them land so that them can go do them business. And here it is. People are run out. And not even a bottle of water. You not care for the people them. That's how me hear it. That you don't even carry a bottle of water. Not even not appalling for cover the people them things. Rent 2 modular home and say, all right, you know, go on shelter. No. Instead, when I tell the people them say, but they must get this and they must get that. And then when they don't want to talk about integrity, integrity and transparency, and humanitarian. Where was the humanitarian efforts on your part when you show up with your leader? Where was it? You could have taken care of 1 case of water, man. Don't know. You never do that. Instead, you're running upon the thing. I could go and beat you over your head with this now.
Application is iniquitous. It may be that the law is not a shackle to the lawmakers. That does not apply to the court, which must.
Where did we hear that famous statement about the law not being a shackle? I think it was a former prime minister who said that, the law is not a shackle. My. How it is our words come back. Let's hear some more.
Dispense justice according to the law. It is the court's view that the application is devoid of sincerity. It is an attempt to pervert the course of justice and an abuse of the process of the court.
Wow. Justice McIntosh speaking as assertively as that, saying, let me repeat, that the defendants seem to have been, quote, misled by politicians into squatting on private property. Notwithstanding their unlawful act, the court empathizes with the gullible defendants. Not our words, his words. All right. So, therefore, what happened when the minister, subsequent to this judgment, then sued New Falmouth Resorts, the owner of the land, and sued them in his own name?
So he then went on now, George, to file a fresh claim. And when you say a fresh claim, new claim. And he placed himself at the forefront now as the claimant and New Falmouth Resorts as the defendant. He sought several declarations. Among them was that he was entitled to compulsorily acquire the land, that the Commissioner of Lands could take possession of the land, and that the land now vested in the Commissioner of Lands. He sought the injunctions I spoke of earlier, restraining the owner from dealing with his own land and from evicting, an injunction from evicting and disturbing the occupants and from demolishing or altering the structures. New Falmouth applied to strike out that claim. And when he says strike out, he's telling judge, don't listen to this claim. It has no place in this court.
Yes.
Throw it out. And the matter was heard by Justice Campbell over 5 days. And in 2014 of February, he refused the minister's application for an injunction and struck out the minister's claim entirely. And he gave several reasons, George, as to why he struck it out.
Yes.
He said that one, they didn't satisfy the statutory conditions. What are the statutory conditions? He says that there was no evidence that the minister actually considered housing conditions in the area. There was no evidence of a prepared housing scheme under Section 4.2, nor a prepared housing scheme under Section 6.2, and no approval from the said minister under Section 11. He was referring to the said act that would allow you to make the declaration, but there are certain preliminary steps that had to be done and taken before and after, before it got to this stage. Those were not taken. What is striking to my mind is the government's own evidence, to my mind, defeated the case. Because the affidavit of Simone Morris Rattray, who was, as at the time, the senior legal officer and the minister's own authorized agent, this is her affidavit, she said that nearly all the occupants had permanent concrete structures with water and electricity and described the settlement as a vibrant community. But Section 6 of the Housing Act requires the opposite.
Yes.
I went through what would be required by
Yes.
Section 6. I can go back through it. Section 6 requires, it deals with clearance where conditions are so bad that's Section 5. Section 6 deals with improvement schemes where the houses in an area are unfit for human habitation through disrepair or sanitary defects, or are dangerous to health because of bad arrangement, narrow or badly arranged streets, or overcrowded. Yeah? Section 6 here, based on the affidavit, it says permanent concrete structures with water and electricity and a vibrant community.
Yeah.
It requires houses unfit for human habitation. I just went through what Section 6 means. He also went on, the judge, to say there was no public purpose. And that is the constitutional core of the case. And I'll deal with it separately. He spoke about the balance of convenience, the fact that the judge, the balance of convenience, the judge thought that it favored the company because the company has been trying to do every single thing to get the people out. And as a matter of fact, when you're seeking an injunction in legal cases, George, there is usually something that you have to put in the application that you undertake to cover damages that arise from an injunction.
Yes.
That was not given.
Yes.
That undertaking was not given.
Yes.
Then the judge went on to say that the claimant's own conduct. He quoted an equitable maxim. He says, he who comes to equity must come with clean hands. Because apparently a valuation of the owner's property had been procured with no explanation of the authority under which that was done. And then the minister had gone on to gazette the declaration after a judge had already ruled. And that was disregarded by the minister. The judge took that into consideration.
So what do you see from these people? They're saying that they are the law. They can go around judge. But hold on. There seems to be a little double standard here. When they're ready, they want to yield everything to the Integrity Commission. Right? My goodness. So when you're ready, you put the Integrity Commission above the Parliament, but at another place, when it suits you, you want to put your parliamentary power, your ministerial power over the judge. Let's look at the whole NARA thing. Here it is. They craft something to get around this delay tactics of the municipal corporations to get things done. And what is it that they put in there? A step in order, saying that the minister can go around the municipal corporation. But everybody have a problem with that. Because why? Because this will get you what you want. Huh? So when it suits you, you can do this. And when it don't suit you, you can do that. Look at it. Dennis Meadows come out and say, him support scamming. Marky G haul him up and him have to apologize and ray. And him have to step away from the seat. So Wickham McNeil could take the seat. Who go there and lose anyway? Because Tova a champion. Right? Here comes I sat now. I say, no man, don't have to scam the government. Supporting as a legislator, as a member of parliament. He's telling people that they can scam the government. Who is the government? The government is the people. So not to scam one another. And government money is the people's money, as George pointed out in our piece earlier this week. Which we all know, but we love to talk about government. This is what people need to get in their minds. That when you go to the tax office or you go to any government agency and you're not getting proper service, it is because it is your own people who are not giving you the service. And stop talking about government this and government that. It is the people. If the person who is offering the service were to consider that this person standing in front of them is a beloved member of their family, and they're going to offer them their best, can you imagine what customer service would be like in Jamaica from every government agency? This nonsense where when we're ready, we talk about government this, government that, the government not doing this, government not doing that. No. It is people who make up the government, and if the service is not being offered, it is a person who is not doing it. For everything that you try to get approved or to get some service and you don't receive it, forget about government. Is the person in front of you. And the whole hierarchy of people who give those instructions. Yes, we need to talk the truth, people, and clean up this thing. And stop making this foolish argument when it suits your government. Government gets money by taxing and charging fees. When you go to the government and you claim you want 100% salary increase, you're trying to tell the rest of the Jamaican people that they must find money to give you 100% increase. And when you finish, you then go back to work and decide that you're going to punish these same people who pay your salary. This is the thing that people are not. It's like there's some kind of disconnect. You think government just have a printing press and just print money? There are rules and there are guidelines. Just like how your pocket have rules and guidelines. Everything your child asks you for, you give them. Is it within your means to do so? And if you give one child something, you may have a shot with another child something. Come on, people. Anyway, I go and beat them over them head with this thing here.
All right. After the break, Tide, we have to take the break. It's 6 o'clock. You're gonna explain to the listeners, from your perspective, why the court found that there was no public purpose element strong enough to compel him to side with the government in this matter. Well, the then government in this matter of the Cooper's Bend land dispute with the owners, New Falmouth Resorts. After the break. Summing up what has happened in this long-running legal battle between New Falmouth Resorts, the company that owns that controversial piece of land, Orange Grove, Cooper's Bend in Trelawney, which was the site of a demolition exercise earlier this week, and we've heard a lot of comments about who's in the right, actions of the government then, the things that the government now ought to do, the rights of squatters, the rights of property owners, all of that. And so we've asked Saeed Bernard to read the judgments, analyze them, and take from the judgments the salient points that can answer the questions that you have about this matter to help your own understanding. Where we had left the conversation at the break was that Saeed had told us that the Minister of Housing at the time, he went to the court and filed a fresh claim. He wanted the court to rule that the minister was now entitled to compulsorily acquire the land, that the Commissioner of Lands could take possession of the land, and that the land was now vested in the Commissioner of Lands. He also sought injunctions restraining the owner, New Falmouth Resort, from dealing with their own land, restrain them from evicting or disturbing the squatters, and from demolishing or altering any of the structures. Justice Campbell heard the matter over 5 days, and he refused the minister's application. And he gave several reasons. Saeed says that very important among the reasons was that the court found that there was no public purpose element of the minister's claim. Why did the court find that there was no public purpose element in this matter, Mr. Bernard?
Now imagine, George, you live in a country where you've worked hard, you've saved, you pull shifts, you've been here from morning and you're still here. You buy a piece of land and the government just comes and say, I'm going to take the property from you, I'm going to buy it from you because I'm going to give it to me. Yeah? That is what the Constitution can't allow.
Yes.
And Section 18 of the Constitution, it allows for the compulsory acquisition of land under that law and compensation, access to the court, but it must be for a public purpose. Yeah? Now the judge, when referring back to Section 25 of the Housing Act, he says it creates a presumption that acquisition for a scheme is for a public purpose. But he held that that presumption is rebuttable and that the court is entitled to look beyond the veil, look beyond the stated purpose, look beyond what is in the affidavits, look beyond what the minister has said and see whether or not it is a sham. Now, this principle of law, George, takes shape from the 1800s in a case called Street and Montfort, ruled in England, where the judge said, you cannot call a spoon a fork, and it must be accepted as a fork. You must look beyond. And if you call it a fork, it does not matter as long as the subject looks and operates like a spoon. Same principle here. So, Justice Campbell went on in paragraph 36 of the judgment, frankly speaking, very blunt, to say the stated or alleged purpose of the claimant, the Minister of Housing, is not for general interest of the community, but merely for private individuals voluntarily associated together for their own benefit. There can be no public purpose or furtherance of the general interest of the community as opposed to the particular interest of individuals, requiring the respondent to locate these families on its land in flagrant breach of the orders of this court. It tells me, George, that Justice Campbell here was very upset as to what took place after his sister judge made rulings in 2007.
Yeah, very well. All right. So, there are some passages that I'm sure you would have highlighted as you read, and they reflect what the court had to say about the overall matter. You've mentioned paragraphs 36 and 38. Any other paragraphs that caught your eye and why?
Yes, 46 of the judgment of Justice Campbell's judgment, 47 as well. He says the Housing Act and the Land Acquisition Act do not provide for the compulsory acquisition of privately owned land in order to transfer an interest to a community of persons who have occupied those lands despite their efforts of the owner to evict. Very important.
Yes.
This dispels any labeling of adverse possession because you're not in open, undisturbed possession.
Yes, it's not undisturbed.
No, it's not undisturbed, despite the efforts of the owner to evict. And furthermore, again, the judge is upset because it is in defiance of the orders of the Supreme Court. I share the view of my brother, Justice McIntosh, that the application of the claimant is insincere and iniquitous. The Constitution protects private property and does not provide cover for the acquisition of private property in order to regularize the unlawful occupation of squatters.
Very important.
He goes on in paragraph 47, I have not been shown any authority that imposes an obligation on a private landowner to make available his land to a community of persons in unlawful occupation in order to prevent those persons bringing on social unrest. The Constitution does not reserve the right to ownership of large tracts of land to persons of any particular social class, color, or creed. Justice McIntosh was driven to describe the earlier application on behalf of the occupants as insincere and iniquitous, the third time now,
yeah.
using these same two words.
Insincere and iniquitous.
I want to take note of those words. Insincere and iniquitous. Insincere and iniquitous. You know what iniquity is? Oh, no, what iniquity is? Iniquity is you loving an evil deed being done. Huh? People who see the wrong and take pleasure in observing this wrong and doing nothing about it. This is what it is. Right? I tell you, the judge, 3 times, the judge used that term, you know. Insincere and iniquitous. Let's continue to listen. Because I tell you, oh, what tangled webs we weave, when we seek to deceive. Yeah, man. Dr. Morris guy. You can't run, but you can't hide, brother. Cause see there, you're not even in politics right now. And look upon the thing where I reach you now. Now you're there. You're back in the news for some deeds where you carry out in the past. Yep.
No doubt because of the total disregard for the defendant's fundamental rights. This court has formed the view that the hardship that has been visited on the defendant appears to be a consequence of a view on which public officials and the claimant seemed to have acted that Mr. Chisholm, and this is the most potent,
Powerful stuff. Read it, Said.
Mr. Chisholm, not being from a line of traditional large landowners, has no right to ownership of such relatively large tracts of land. If I am correct in that view, the remedy to that malady is an emancipation of those minds so enslaved.
Wow. Wow.
I don't want you to miss that. It's basically saying a Jamaican businessman is treated differently by the state because he did not come from the traditional landowning class.
Yes. Yes.
He's saying, in other words, George, the state would not move this way if it was against a plantation family.
Yeah.
So you see we come back to the whole thing. Now we know why it is them a run back a Marky G. This is the thinking. This is why them so angry with Andrew. Cause Andrew who not come from nothing. How dare him be Prime Minister of Jamaica? Ay. Huh? So if you're not from the 21 families or whatever number it reach now, you're not supposed to have certain things. How dare you? Landowner. How dare you? Ay. Story I come to bump for sure. I could go and listen.
Big name, old money, he's not. So because he's a small man not supposed to own so much land. So because he's a small man, not from a big landowning family, we're moving against him to take the land, is what the judge is saying.
The judge is saying it would not have occurred if that were the case.
All right. So why did the court say the minister could not bring the case a second time, could not keep going to the court to get his way?
So, two related principles, and I have to spell it out for the listeners. Res judicata, that means a matter already decided by a competent court cannot be litigated again. And abuse of process, a broader principle, that covers a party raising an issue that could and should have been raised the first time. So you can't raise it now that you just think about it. You should have raised it in the previous case. The minister answered that question to say that the claim in 2007 he was not a party to. Because there were 99 defendants, he was not a party to that. Yes? Now, he also went on to say that that's a private law matter. Him now being involved, the Minister of Housing, it now becomes a public law matter. The judge rejected that, and the Court of Appeal also rejected that argument. The affidavit in both sets of proceedings came from the same deponents, describing themselves as the minister's authorized agents. The minister's officers appeared in court. The same ministerial declaration was the foundation of both. The Court of Appeal actually said, in my view, the minister cannot now seek to detach himself from the proceedings by merely stating that he was not a party to those proceedings, especially where it is clear that at all material times he proposed to act on behalf of the 99 defendants or to help them achieve their original objective in litigation.
Very well. 6:14. I'm not hearing go to break yet, so I'm going to soldier on. What did the Court of Appeal decide now, Said, in 2016?
So the Court of Appeal now, having heard the case, Justice Williams wrote the judgment. And a part of this panel, I will say, is Justice Phillips and Justice Brooks, who later on became a president of the Court of Appeal. Now, the Court of Appeal upheld every single material point of the Supreme Court. It upheld everything. On the statutory failures, it went further than the Supreme Court. It found that the 9-month period under Section A2, not satisfied. The evidence of ministerial approval under Section 11, not satisfied. The compliance needed under Section 8.1, which requires publication of a notice stating that there was a plan to be inspected and all of that, not satisfied. So overall, the Court of Appeal said what appeared to have been at play was, at best, a misguided attempt to use the provisions of the Act in an effort to achieve certain social objectives for which the Act did not provide. The conclusion then of that judge, Justice of Appeal Williams, the later claim having been in substance the same as the earlier claim and appearing to have the effect of attempting to circumvent the orders of Justice McIntosh, they clearly amounted to an abuse of process of the court. That fact, coupled with the minister's failure to demonstrate compliance with the requirements of Section 6 of the Act, helped to seal the fate of his applications. Since then, 2016, no further appeal to the Privy Council. That is where the litigation ended.
Yes.
April 2016.
April 2016, all of the court matters around this matter ceased to be. They ended April 2016. So therefore, with all of the court matters ending in April 2016, what is the legal effect of all of what went before, and why can the owner now move to demolish?
I have to take a deep breath.
Yes.
This is tiring. So the legal effect of what has taken place now, George, and I'm trying to put it as simple as possible, because every legal route that the occupants had, in other words, if those occupants came to me and they showed me all of this, I just said, you have no other choice at this point. You've tried everything. The minister tried to help you and the minister failed to. You don't have any choice at this point. So their claim to the land by adverse possession was tried and rejected in 2010. Order for recovery of possession, never appealed, stands final. Application to stay that order was refused in 2012, not appealed. The government's attempt to acquire that land struck out in 2014. The appeal against that ruling in 2014 was dismissed in 2016. No compensation, no damages, no cost ordered against the occupants have ever been paid. So the owner holds a final unappealed judgment of the Supreme Court for possession, together with an order that the structures be removed and no legal impediment enforcing it. What happened on Tuesday morning is literally the end of the road. It is the end of the road. It's not something new that came up. It's not the beginning of a new road. It's the end of the road that started in 2007.
Let's take a quick break there, Andrew, to give Saeed time to catch his breath, because there's still more ground to cover. Because I want to ask you after the break, was the owner required to give the residents notice before moving to demolish? That after the break. As he has analyzed the court rulings on this matter, and he has highlighted the opinions of the judges who've sat in on the matters brought before them concerning the ownership of the land and the possession of the land and the occupation of the land. And we have a few furlongs to cover, just a few more. So just to recap quickly before the break, Saeed told us that the 99 defendants, including a nebulous group called Persons Unknown, yeah, their claim to the land that is owned by New Falmouth Resorts, that claim to the land by long possession was tried and rejected by the court in 2010. The order for recovery of possession by the owners of their land, that order was never appealed and stands as final. The application by the occupiers of the land to stay an order was refused in 2012, and they did not appeal. The government's attempt, when the government entered the fray, when the Minister of Housing, Dr. Maurice Guy, entered and sued in his own name, that attempt to acquire for the land for the occupiers was struck out by the court in 2014. The appeal to that striking out was dismissed in 2016. The court along the way ordered for the occupiers, the squatters, to pay compensation, to pay damages. None of that was ever honored by the occupiers of the land. Yeah? And so the owner, Saeed Bernard, says, holds a final unappealed judgment of the Supreme Court for possession, together with an order that the structures be removed and no legal impediment to enforcing it. He said, Saeed Bernard said, what happened on Tuesday was the end of the road, not the beginning of a new one. So therefore I ask you now, counsel, was the owner required to give the residents notice before demolishing?
Judge, in the break, before I answer that question directly, this issue has been made to be a political class issue.
Yes.
A class issue. Poor people, land belongs to the people and all of that. What the judge was doing here, and I think it's important to bring it up, because from this time, 2010, 2013, the judge picked up on that and made the declaration that he did. He drew on the Bob Marley, he drew on the ideology of Marcus Garvey in saying that if this was a plantation owner, a family name owner, this case would not have been here. It pales in comparison to what we're hearing now, where it is poor people, so they're supposed to get the land. What about persons who have worked to try and bring themselves up to the social ladder? And this is where the judge is having the difficulty to say the Constitution goes both ways. It goes both ways. Now, the court, where am I? Yes. Demolishing now?
No, yeah, well,
Yes.
no, I asked you if the owner was required to give the notice. There's
yes,
notice before demolishing.
right.
Yes.
So, as it relates to this, I am going to stick to the facts as I have seen them in the case. A judgment for recovery of possession is enforced by what is called, ladies and gentlemen, a writ of possession. And that is executed by a bailiff. So you'll recall at the start of the program I said that a bailiff was there, meaning that the bailiff was there on the court's business
Yes.
to execute an order.
He was supervising the process of
Right,
demolition. Yes.
Right. The writ of possession is what is executed by that bailiff. The occupants in this case, the parties to the 2007 claim, they were served, they'd have to be served, represented, attended trial, order made against them. So in law, the judgment itself is now their notice. There is no requirement that fresh notice be given.
Yeah.
None. Not to my mind.
Yes.
Yes? And because no fresh notice is needed, because the court has already ordered them, they have the order.
Mm-hmm.
That said, 3 qualifications are there that I will make. Firstly, the 2010 order bound the 99 named defendants, and the evidence in both judgments is that the settlement grew after 2010.
Yes.
So whether every person whose house was leveled on Tuesday forms a part of that claim or a successor, they are bound by that order. And whether or not they are saying that they are not the 85th defendant by being persons
Persons unknown.
unknown, that is a matter that, to my mind, a question of fact, I cannot answer based on the judgments. Secondly, an enforcement officer executing a writ of possession, they have to act within the terms of that writ. And thirdly, lawfulness and decency are not the same thing.
That's right.
They are not the same thing. The law permitted this. The law did not require that it be done at 3 o'clock in the morning. But the law allowed it. Simply put.
Yeah, all right. Very well. Can a judgment from 2010 still be enforced in 2026? Is it too late?
So that's a fair question because the court runs on time. But the short answer to that is a judgment does not expire. It doesn't. It remains a judgment until it is appealed and set aside, satisfied, or reversed by another judge. That did not happen here. The only thing that changes it to my mind is the time. Because 6 years have passed since the date of the judgment. The rules require that the judgment creditor, as in the person who the judgment is in favor of, the rules require that they get permission from the court to issue the execution as regards the judgment, to act on the judgment. And of course, the court would want to know, why was there a delay and all of that. Yes? But that does not come into play, George, because the formal order here that has the defendants before the Honorable Justice Chester Stamp in Chambers video conference dated the 19th day of May 2026, and that's the important part. 19th day of May 2026. It says, on the hearing of the notice of application filed on March 30, 2026, and coming on hearing on the 19th day of May 2026, it is hereby ordered as follows. An order is made, granted in terms of paragraphs 1, 2, and 3 of the notice of application for court orders that was filed on March 30. Paragraph 2 is to be amended to substitute creditor for the word debtors. I do not have the notice of application, so I cannot read that verbatim. But it goes on to say that the claimant be reissued a writ of possession. What does that mean, George? It means that a writ of possession was issued prior.
Before, yeah. So reissue. There you go.
Yeah?
Yeah.
So this is a reissue, and you have to go back to the court to get that. To recover possession of the approximately 14.5 acres of the northerly portions of the land known as Orange Grove, south of Cooper's Pen and Burnwood Beach, being lands registered at the volume 1008, folio 6b6 of the registered book of titles in Trelawney, containing by survey 284 acres, 1 rood and 22 perches.
Yes.
Of the shape and dimensions and buttings as appear by the plan thereof. That's the language used on.
Yes. To discuss the lay of the land anyway,
Right.
with the things that are on the features.
Correct.
Yes.
So, in other words, George, the owner has the order, a fresh order,
May 2026.
to act on.
There you go. All right. What about the report? Now, we carried a report earlier this week based on some checks by our business and enterprise editor, Chevron Campbell, that the company New Falmouth Resorts was at risk of being struck from the company register. So someone may ask, what effect does that have on the ability of New Falmouth Resorts to proceed on the basis of a court order, given that it is risking deregistration from the company's office?
And that's a good question, but a separate issue. It should not be used to conflate or confuse the property issue at question. As you know, anti-money laundering and FATF, we've been in FATF, and in order to get the country in a particular position where money laundering is concerned, the Companies Office of Jamaica, along with FID, for example, customs, and various agencies, have to have a database of beneficial owners. All right? Now, what happens with New Falmouth Resorts is that they run the risk of being struck after 3 years for failure to file their beneficial ownership declaration. And that's a declaration now that every single company in Jamaica has to file. Right? So that became an amendment. It became a requirement through the amendment of the Companies Act, and it forms a part of the anti-money laundering framework. But that, George, does not undo the judgment. To my mind, it does not affect the title.
Yes.
It doesn't at all. A company that is in the process of being struck off is still on the register and still owns the property. And even if a company is eventually dissolved, the consequence is not that the squatters can take the land. The consequence under the Companies Act, and I'm in the teaching mode, so I might as well go there, is that the property passes to the Crown
Yes.
as ownerless property. And a company that has been struck off can apply to be restored to the register. At which point, it would be treated as having continued in existence.
Yes.
So the deregistration story, it does raise legitimate questions about transparency and other things that have to be dealt with by them.
Yes.
But it does not change the story behind the land.
All right. After the break, Said, we have to take the break. I have one more question, and it concerns the social significance. And I wanted to bring back in that answer, if you can, what the judge said about the antecedents of the gentleman behind New Falmouth Resorts, and how he would have worked to acquire his property, which the government then tried to take from him over so many years and so many court proceedings. After the break, we get that as we wrap up this explainer nationwide style, nationwide at 5 on this Friday afternoon, concerning the Cooper's Pen.
So I guess now we're going to hear the actual now reason why the government of the day moved against this gentleman the way they did. Yes, let us hear that now.
Land dispute and the steps that have been taken by 99 defendants, including a group classified as persons unknown, and the Minister of Housing, Dr. Maurice Guy, and our PMP administration, the steps that have been taken to acquire the land so that the people there could own the land, and the efforts that the owner of the land, New Falmouth Resorts, has made over all those years to take possession of the land. The court has ruled consistently in favor of New Falmouth Resorts, telling those who occupy the land to leave, demolish what they built, and to pay costs to New Falmouth Resorts. None of the court's orders have been obeyed. And in fact, after the court ordered certain things, the Minister of Housing went and gazetted something else. And the court was very upset that that had been done. I asked Said Bernard, after this masterclass from him, to sum it up by speaking to the social significance of this Cooper's Pen land dispute.
The social significance, George, is quite enormous, and it goes beyond Trelawney. Squatting in Jamaica is it's nothing on the fringe. Informal settlements are now a very large part of Jamaica. And behind almost every one of these settlements is the same set of facts. People with nowhere to go, land they do not own, years of political tolerance, and eventually a reckoning. What Cooper's Pen shows me is what happens when that reckoning is deferred for 2 decades. Justice McIntosh identified the underlying wrong as early as 2012, when he described the defendants as having seemingly been misled by politicians into squatting on private property, and said the court empathized with them while recognizing that what they had done was also unlawful. That is the tragedy of the case in a single sentence. The persons who lost their homes on Tuesday morning are, in large measure, the ones who were let down. They were encouraged to stay. They were told help was coming. Affidavits filed on their behalf by public officials. Minister declared their community an improvement area. And when all of that failed in court in 2016, nothing was put in its place. Nobody relocated them. Nobody bought the land. Nobody told them that 10 years of silence did not mean that the judgment had no effect. And it is also worth saying here plainly that the owner of this land is himself a Jamaican businessman who, on the evidence accepted by the judge, spent more than a decade writing to government agencies, to the housing agency, to the Prime Minister, asking for help to resolve the position of the very people on his land. And he received no help. I want to repeat that, George.
Please.
The Jamaican businessman, he had people on his land. He spent 10 years writing to government agencies. On the evidence in the case, you can go and read it yourself. He wrote to the housing agency. He wrote to the Prime Minister asking for help to relocate the people on his land. He got no help. So this is not the case of a landowner who did nothing and then reached for a bulldozer. It is a case where everybody was asking the state to act or the state not to act, but the state did not act. And then there's a timing of this because many of the families just went through Hurricane Melissa and Darby building. But whatever the legal position, that fact will and should shape how we feel about what happens. Because a court order, it does not go stale. You can't just ignore it and let it just sit there. It might just be sitting and waiting. So I think the bigger lesson this afternoon, this evening, is for anyone who is occupying land they do not own. The message is to regularize your position now, while there is still someone to negotiate with. For landowners, the message is that the courts will protect a registered title, but that enforcement gets harder the longer you wait. And for the state, the government, the message is the one both courts have already given. The Housing Act is not an instrument for solving a political problem, and the Constitution is not a mechanism for taking one Jamaican's land to give to another.
Thank you very much, Counsel. Thank you very much. Thank you very much. Thank you very much. Listeners, we've put this into the public domain. We've leaned on Saeed's expertise and experience to look at all of the court proceedings concerning this matter. And that's where his answers come from. And the opinion he has formed is based on what he...
So people, what I recognize in Counsel's closing statement there, Counsel was being very careful to not call out which Prime Minister this person wrote to. However, regardless of the Prime Minister that he wrote to, the court had already ruled that the people were supposed to get off his land. They were even supposed to pay him money because of the illegal possession of the land. All of these things the court had already ruled on. So the point about him writing to the Prime Minister and to the government and whatever, all of those statements would have been null and void because the court had already ruled. And it is a dangerous thing if a Prime Minister inserts himself, and Andrew Holness has been known to stay away from inserting himself into legal matters. Okay? He does not insert himself in legal matters. If the court has ruled, he does not insert himself. And people always want him to come out and say this and come out and say that. For you, all you other people out there who take up this blogging thing and have channels and go, if you just send it for likes and clicks, I understand. Okay, because you got to do what you got to do and you got to eat. But at least do it with the understanding that he, as Prime Minister, and his government should not insert themselves in matters that the court has already ruled on. You keep saying, oh, he should do this and he should do that. There's no basis, because at a certain point, the court will make the order and the state will not interfere. That is what has to be clear. That when the court has ruled, the state will not interfere. Okay? So the court had already ruled the man's land was his land. The people on it should get off the land. Right? For more than 10 years, this man has waited. Well, it's now time, and the court, by way of the bailiff, it was not the landowner who just hired somebody to come with a bulldozer. And he was not required to give any further notice because the court had already ruled and already stated that the people must come off the land. The people must come off the land. And they were supposed to pay. As a matter of fact, they owe him money. Right? If I'm not mistaken, it's something like 99 times 50,000. That's the amount of money that the people owe him. Because that money that he's being offered, I'm sure, is to help him, is to defray the cost of clearing the land so he can do what he wants with his land. It's his land. Let us be clear. If it were your land and other people move on to it, what would be your feeling? You would feel that it's okay that government can just step in and just take away your land and give it to other people? No. And the Constitution protects against those things. So, this presentation, this breakdown that Nationwide did was excellent. It was needed. Because a lot of people just tiptoeing around it, and some people just going on about it for likes and clicks. But here it is, we have it. And to think that there are so many lawyers inside the PNP, right? This is what you should have done before you run out and say all the things you said. Now you all have egg all over your face. Huh? And Mr. Isat, you're going to lose the bet because the Prime Minister cannot give these people no house and no land. And if he does, it certainly will not be the land that they're on now. And then the Prime Minister needs to be careful. Because if you do this thing where people can go and take people land and the court will throw them off and then the government just give you some land somewhere else. That is a bad precedent. Because it means that other people will then try the same thing. Of course, for those who wish to try it, keep in mind how long this process took. This thing been in the courts for more than 20 years. Okay? You have 20 years. In 20 years, you could have found a piece of land and bought it and paid it off. Why go through all of this hassle? And there's no guarantee that you won't get anything from it at the end of the day. So yeah, we decided, boy, we hear this thing, we'll come in and comment on it. And listen, hope you guys got something from all of this. And hey, this is Faada Pow, just doing his thing, for those who interested to know, we discuss these issues and we give our 2 pence, 2 cents, 2 pence, 2 whatever on these matters. And hopefully, you get something out of it. If you don't get anything out of it, thanks for being here anyway. And if you didn't catch it live, you can always catch it after the fact. All right? So, yeah, Faada Pow here. And we're just doing what we're doing. People, stay safe. And maybe one of the times you guys might decide to utilize it and call in and share your opinion on the matters. Take it easy. Talk to you again.